Hello everyone, my name is Lalit Soni and you are watching Polity This Week by Drishti IAS. In this episode, we'll be talking about certain topics of polity which has been in news in the past week. These topics can be important for us, so we will try to understand the concept behind it and then some static portion related to that. So let's start. We'll be discussing 4-5 topics today. So the topic is one is sub-classification in SC/ST reservation. So you must be aware that Supreme Court has said that states can go for the sub-classification in the SC/ST reservation, and after that government has also made certain comments, and then that is why this issue was there in news. So we'll be discussing that. Then we'll be seeing conflict of interest, and then there will be Security and Exchange Board of India. So basically we'll be taking up these two topics together, because if we are talking about the news was related to a particular report. The name of the report is Hindenburg report, and because of that report there was this term which was in you can say discussion, because in that particular report it was said that the SEBI, Security and Exchange Board of India's chairperson, had some kind of conflict of interest in an investigation which is going. Okay, so we'll be discussing the term in conflict of interest, and then we'll be talking about the Security and Exchange Board of India as a, you can say, statutory body. Okay, after that we'll be moving to the next topic, that is furlough and parole. When we talk about furlough and parole, these terms are related to conditional release of certain category of convicts which are there in the jail. Okay, so we'll be talking about these two terms. We'll be seeing what are the difference between them. Okay, then legal parental rights in ART. Parental rights we'll be discussing, and then ART. When we talk about ART, is assisted reproductive technologies. Okay, if for any reason a couple is not able to conceive naturally, in that case there are assisted reproductive technologies. Okay, like surrogacy etc. are there, or you can say sperm donor, egg donor, and then these are cultivated in the, you can say, a zygote is cultivated in the laboratory and then it was introduced to a womb. Okay, so ultimately these are the technologies, assisted reproductive technologies. Now we will be talking about the legal aspects. We will be seeing that the child who is born out of such practices or such technologies, now what kind of rights they have. Second thing is what kind of parental rights the person who has given the you can say the specimen like semen or the eggs, what kind of rights they will have. So we will be talking about all these aspects today. So let's start with the first one. Before that, I would like to tell you that on the occasion of Independence Day, Drishti IAS has come up with an offer, that is flat 40% discount on all online pen drive courses, test series and DLPs, and this offer you can avail up to 18th of August. So you can go, and there is a link which is given in your description. You can click on that link and you can avail the offer. Other than that, you can call on these numbers which is given 8010 440 then 87501 You can call on these number and you can avail the offer. Otherwise you can also download the Drishti Learning app and then you can avail the offer. So that is about the specific discount which has been given by Drishti IAS on the day of, or the occasion of, the Independence Day. Now again that is valid up to 18th of August. Now coming to the first article or first topic, that is sub-classification in SC/ST reservation. Okay, so when we talk about the reservation in India, you know that as per article 14 there is the right to equality, and then there are article 15 and 16 which talks about the affirmative action. Affirmative action is something, or you can say the state can go for some kind of classification which is reasonable, and on the basis of that they can provide reservation, okay, in the education institutions as well as the employment. Now that is because it is important to have equality of opportunity as well, and in that regard we have the concept of reservation. Earlier when we talk about initial days when it was drafted, at that point of time it was supposed to be there for 10 years, but then it was for various reasons increased. Okay, now coming to a particular issue, that is sub-classification. When we talk about OBC reservation, you know that we have sub-classification, that is criminal layer and non-criminal layer. Now there are various criteria for that. So on the basis of that criteria, that classification is there. Okay, and then there was this Indira Sahani judgment in which this classification was upheld. Now moving further, now there is a demand that similar classification should be there in the SC/ST reservation as well. But the problem is, do states have such rights? Do states have such rights to make such changes? So that was the issue. And then for various cases in the judicial precedents, if we look, there are various cases. Okay, 𝐸 𝐏𝐻𝐤 case is there, and then there is this Devender Singh case. Okay, in that case it was said that there were various aspects which was seen, and then ultimately there was this 7-judge bench which was supposed to give verdict on that, and that bench has given a verdict. We'll be talking about that, but that bench has said that yes, state can go for such subclassification. Okay, so let's talk about the issue. We'll start with the reservation itself. We will see that which article of the constitution talks about the SC/ST reservation and what is the process therein. Okay, so first let's talk about article 341. 341 is basically empowering the president to create a list. Okay, and now that list is basically a list of SC/ST communities, which is basically talking about the reservation. Now specifically speaking, if we talk about article 341, that is talking about the scheduled caste. Okay, now let's see, empower the president to specify the caste, races or tribes in a state that are deemed scheduled caste for constitutional purpose. Okay, now again, this classification is just for the constitutional purpose, or you can say administrative purposes. Okay, now once a caste is included in the presidential list, it becomes a part of a single class eligible for reservation in education and the public employment. That is what, you know, this particular, you can say, article is deriving the authority from the article 15 and 16. You can say that is equality of opportunity. Okay, moving further, you will be seeing parliament has the exclusive authority to amend this list. Now once president is, you know, giving this particular list, okay, after that parliament will have authority to amend or make any changes in this particular list. Okay, moving further, reservation for SCs. The SC collectively receive a 15% reservation in education and the public employment. The question of whether the state can further subcategorize SC within 15% reservation, that was basically a legal debate. Okay, so we have seen that in the recent judgment also, the court was looking into this issue only, whether states can actually go for the subclassification, because we have seen that parliament has right to change the list, but once list is there, state is not changing the list, state is changing the way that reservation is divided. Okay, so basically, can state go for subclassification? And now this particular subclassification will be based on certain criteria. Obviously, if you are dividing certain category on a particular line, then there should be a criteria for that. Okay, so can state do that or not? Now question related to this subclassification arises because you know that when we talk about a particular section of the society which is getting reservation, so there are certain people who has got the reservation and got the benefit out of it, and they have improved their situation. Okay, their economic situation, their educational background, etc. So do these people need such reservation or not? That is the basic question behind it, and that is why there is this question that if someone has got this reservation and the benefit out of it, then there should be a subcategory that there should be the more vulnerable section should be given the benefit out of it. Okay, so that is the idea behind it. Now coming to the judicial precedent, if we talk about, so there was this case in 2004, that is 𝐸 𝐏𝐻𝐤 versus State of Andhra Pradesh. Before that, if we talk about, the issue of subclassification was discussed in Indira Sahni as well, and it was upheld in the Indira Sahni judgment. Okay, so when we talk about the Indira Sahni judgment, that is very important with respect to reservation, because there was a 50% cap which was also put in the Indira Sahni, and then this subclassification was also discussed in the Indira Sahni judgment. Now coming to the next part, that is basically talking about the when we are talking about Indira Sahni, one more thing is that subclassification is only with respect to the OBCs. Okay, because Indira Sahni case is also known as the Mandal Commission case, and Mandal Commission was related to OBC. Okay, the reservation for the OBC. Now coming to this particular point, that is 𝐸 𝐏𝐻𝐤 versus State of Andhra Pradesh. Now Supreme Court ruled that once a caste is included in the presidential list, it forms a part of single homogeneous class, which we have seen that it forms a class of single homogeneous class which is only for the constitutional purpose. Okay, now the court held that the states lack the legislative power to create subclassification within this class, as it would violate the right to equality. Now the thing is, Supreme Court at that point of time thought that since it is a single homogeneous class, now subcategorization would be against the right to equality. Okay, so in 𝐸 𝐏𝐻𝐤, they said that state cannot go for such subclassification. Moving further, then there was this case, that is Devender Singh case 2020. The Supreme Court hinted at the constitutional validity of the subcategorization and suggested that the larger bench should decide the matter. They have hinted that such sub-classification can be done, but they have put it on the larger bench. Okay, now there was this larger bench which was constituted, and that bench was a 7 judges bench, and that particular bench recently has decided in favor of the sub-classification. See, a 7 judge constitutional bench has revisited 2004 Chennaiya judgment and decided whether sub-classification of SCs is constitutionally permissible if state assemblies have the authority to introduce laws with respect to the sub-classification. That was the question, whether they can do it or not. There is a discussion on applying creamy layer principle to SCs, which is already in use for OBCs, which we have talked about, to ensure that the reservation benefits the most of the disadvantaged section. Okay, now coming to the judgment, in this particular judgment, so recent ruling if we are talking about, they have challenged the idea that the inclusion in the presidential list create a uniform homogeneous class. In Chennaiya it was said that it is a uniform homogeneous class, and that is why you cannot go for the further sub-classification. In this particular ruling, they have challenged that idea, and they said that we can go for the sub-classification. Now here you can see Supreme Court indicated that internal differences among the SCs can be justified for the sub-classification to address varying degree of disadvantages. Now within the SC community, there are various sections which has actually got the benefit, and because of which they are having better living conditions or living standards, and that is why there is this gap which has been building over there, and the person who is really in the need of such a reservation is not getting it, and that is why sub classification can be done. The court acknowledged that the states under Article 15 clause 4 and 16 clause 4 can make special provision for the SC and may use this power to identify varying level of the social backwardness within the SCs. So basically here they have said that deriving the authority from the Article 15 and 16 subclause 4, from there they have said that state can go for sub classification so that they can actually categorize these community on the basis of the social backwardness within the SCs. Okay. Now state must justify sub-classification with empirical evidences and reasonable rationale which can be challenged in the court. But you can go for the sub-classification, but there should be a reasonable basis. Okay, there should be an empirical evidence that suggested that this sub-classification is necessary. Okay, so ultimately right now the position as per the Supreme Court's ruling is that state can go for the sub-classification, and this sub-classification should be on the basis of an empirical evidence, or there should be some kind of rationale which is attached to it. Okay, so that is about the sub-categorization or the sub-classification in the SC reservation. Now we can move further to the next topic, that is basically related to conflict of interest. Now what happens is that there was this particular fund, okay, which was operating from the Mauritius and Cayman Island, etc. These are basically tax haven countries. In that particular fund, from where there was some money which was rationalized or used in some kind of you can say the money laundering situation might be there. There is a investigation which is going on, but there was some money which has been transferred from one account to another account, and that is from a prestigious group, and because of which there was this report, that is Hindenburg report, which was there last year, which said that the group, that is Adani Group, was involved in that. Okay, or you can say the funds that is belonging to Adani Group. In that particular group, there was certain share or some part of that particular fund that was somehow having some connection with the current SEBI chairperson. Okay, now the new report comes, and that new report highlights this particular part, that there is an investigation going on with respect to that particular fund, and in that particular fund the current chairperson of SEBI has some kind of stake. Okay, and now since SEBI is the authority to go for the scrutiny of such cases whenever there is some issue which is related to the stock market or the security market, so that is why they are saying that there is this conflict of interest, because the chairperson itself has some stake in that particular fund. Okay, now SEBI has come to the defense of the chairperson. They have said that we have rules and criteria, we have this particular guidelines with respect to that. The chairperson has already declared that they had the stake in that, and she has recused from getting involved in that particular case. Okay, so that was there, but the thing is, the conflict of interest as a concept was in news, so we will be talking about that. Okay, so now coming to the conflict of interest, and then we will be discussing the Security and Exchange Board of India as well. Now coming to the conflict of interest. The conflict of interest refers to a situation where individuals' personal interest or the financial interest may influence their ability to make impartial decision in their professional capacity. So basically, there was some kind of interest which is there, which might influence your decision making capacity in the professional sphere. Okay, for example, if there is this examination, okay, and there is this particular, let's say 80% seats will be fulfilled by the examination, and then 20% seat will be fulfilled by the management of a particular institution. Okay, so we know that there is this management quota, etc., and then there is a person who has given the examination, and he has also applied in the management quota, and the uncle of that particular person is there in that particular institution as a post of principal. Okay, now that is the situation of, and he is the authority who will decide on the, you can say, admissions. So basically now that is the situation of conflict of interest, because there is a personal equation with the applicant, and this particular person is there in the decision making position, so there might be some kind of bias. Okay, so that is conflict of interest. Again, moving further, this is what is the situation where personal interest are influencing your professional decision making. Okay, so that is conflict of interest. Now moving to the next is actual conflict of interest. Now we are talking about this as a term, as a conflict of interest. Now actual conflict of interest is a situation, here you can say that the actual conflict of interest arises when an individual's personal interest directly conflict with the professional duties. Okay, personal interest versus professional duties, that is your actual conflict of interest. Now for example, here two examples are given. A government official who holds share in a company that is bidding for a government contract. Okay, now there is this person, let's say someone is there in let's say PWD, and there is this company, construction company is there, and he is a shareholder of that particular company, and that company has actually applied for a tender. Okay, now if this person holding the share of that particular company is in the decision making position, then it is a conflict of interest. Now moving to the next one, a judge who owns share of a company that is involved in a case before them. Okay, now we will understand this example as a example of the current situation, that is SEBI. Okay, so SEBI is the authority which is deciding, or you can say scrutinizing issues which are related or which are happening in the security market. Okay, so we can say that SEBI is kind of a judge over here. So SEBI is judge over here, and they are having some share, because when we are talking about the SEBI's chairperson, she was having some kind of shares or the stake in the fund. Okay, so own share in a company that is involved in the case before them. Now since this report has came, Hindenburg report has came, and after that there was this scrutiny which is going on, so there is a case which is pending. Okay, so that is why it is a situation of conflict of interest, so we can understand it like that. Okay, now coming, so that is the concept which we have discussed. Now coming to the next part, that is Security and Exchange Board of India. Okay, so since it was also in news because of the same reason, so we'll be talking about that. Coming to that, Security and Exchange Board of India is a statutory body established on April 12th, 1992 in accordance with the provisions of the Security and Exchange Board of India Act. So there is this act, so we can say that it is a statutory body. Okay, now moving further, the basic function of the Security and Exchange Board of India is to protect the interest of the investors in securities and to promote and regulate the security market. Now why it is important to protect the interest of the investors? Because once investor, or you can say a person who is buying a share of a company, now he is a small shareholder because he has taken, let's say, some 10 or 15 units of the share, or let's say some 100 units of the share. But the thing is, he is not in the direct control, or you can say he is not making sure that how the working of the company is happening. Okay, so he is outside the management. So to protect the interest of that particular person, so that the company do not take undue advantage of such people, that is why we have Security and Exchange Board of India. Okay, other than that, that is to regulate the security market, so there is no unhealthy competition which is there. Okay, other than that, there are issues like inside trading, etc., etc. These are belonging to economy, so we will not go into that. Just understand that to protect the interest of the investors, we have Security and Exchange Board of India. Okay, now coming to the specific functions and the power, if we talk about, here you can say SEBI as a quasi-legislative and the quasi-judicial body. So as I told you, SEBI will be going for the legislative, if we talk about, so that is a regulating body, and if we talk about quasi judicial, so they are also going for the scrutiny. Okay, so that is why they are quasi legislative as well as the quasi judicial body, which can draft regulation, conduct inquiries, pass rulings, and impose penalties. Okay, moving further, it functions to fulfill the requirement of the three categories. Okay, three category. One is the issuer. Now issuer is the company which is issuing the share in the market. Okay, so basically to issuer, SEBI is providing a platform. Okay, so here you can say by providing a marketplace in which issuer can increase their finance. Okay, he will issue the shares and then take finance from the market. Moving further, second is investors. That is the most prominent and the specific function of the SEBI, by ensuring safety and supply of precise and accurate information. Okay, so since they are not in the direct touch with the management, so that is why SEBI will be there to provide the safety and the supply of precise and the accurate information over there. Then intermediaries. When we talk about the intermediaries, these are the, you can say, certain traders etc. are there, which are basically working on the commissions. Okay, so for them also they are kind of providing a platform by enabling a competitive professional market for the intermediaries. Okay, so that is about your SEBI's you can say some function. Now SEBI perform a function of registration and the regulation of the working of venture capital funds and collective investment schemes, including the mutual funds. It also works for the promoting and regulation, which we have already talked about. Okay, then moving further, SEBI's chairperson, this is not chairman, chairperson. Chairperson is basically, when we say, it is a gender neutral term. Okay, so instead of chairman we would prefer chairperson. SEBI chairperson has authority to order search and seizure operations. SEBI board can seek information such as telephone call data or for any kind of specific information with respect to any person or entity in respect of any scrutiny or the security transaction which has been under the scrutiny. Okay, so basically there are certain powers of investigation authority as well, so they can go for the seize of particular assets as well. So these are the function of SEBI which we have seen. So basically in this article we have seen that SEBI is a quasi judicial and the quasi legislative body. It is a statutory body, and there is this act which was there on the basis of which SEBI was established. Okay, and the primary function of SEBI is to protect the interest of investors alongside the regulation and the, you can say, facilitation of the security market. Okay, so that is about SEBI. Now moving further to the next one, that is what is parole and furlough. Okay, so recently there is this person, that is Baba Raham Rahim. He has been this Dera Sacha Sauda, you can say that there was this institution, and he was the promoter of that particular institution, and he has been arrested and convicted in certain cases, and later on he is now getting a furlough. So that is why this furlough was in news. So I thought that furlough and parole should be discussed, because these are two different terms which is used in a similar kind of concept. When we talk about furlough and parole, both are conditional release from the jail term, but the thing is there is a difference. We'll try to understand the difference. Okay, now let's start with the parole first. Okay, now parole refers to a prisoner's release, or you can say time bound release before the end of the sentence. Okay, so let's say there is this prisoner who has the sentence of 14 years. At the time of 7 years, okay, there was certain death in the family, or some kind of marriage was there in the family, and because of which he wanted to go out. Okay, so at that point of time he can apply for the parole. Okay, and this parole will be given by the authority on the basis of the reason which has been mentioned. Okay, and second thing is that authority can also reject the application. Okay, so that parole is not a matter of right. Okay, it is on the discretion of the authority who is giving it. Okay, now it is a privilege given to the prisoner to return to the society and socialize with the family and friend. Parole is not a right, is given to a prisoner for a specific reason, such as death in the family or wedding of the blood relative. Now it may be denied to a prisoner even when he makes out a sufficient cause, if the competent authority is satisfied that the releasing the convict would not be in the interest of the society. Okay, so in cases of certain heinous crimes etc., it is understood that we will not be giving such parole to such person. Okay, so otherwise also, if there is a sufficient cause that says that you can say there is this sufficient reason to believe that this person, if he goes out, it will not be in the interest of the society, then parole can be, you can say, rejected. it can last up to 1 month, okay, and can be extended under special circumstances. So this is about parole. Here you can see there are certain exceptions, that is crime against states or the threat to national security and murder, rape of children and other crimes. In such cases parole is denied unless the issuing authority decides otherwise, okay. So basically it is on the discretion of the deciding authority, okay. Now moving to the next part, that is basically your furlough, okay. We have seen that in parole there should be a reason first. Second thing is that is not a matter of right, okay. It is on the deciding authority whether to give the parole or not. Now coming to furlough. Furlough is little bit different because it is also a time bound release of a person, okay, and for whatever time he is outside, okay, for let's say 15 days, that will also be counted in the time period of the imprisonment, okay. So that is kind of a remission, okay. Now you will be seeing, unlike parole, furlough is seen as a matter of right. Now this is a matter of right, okay, for prisoner to be granted periodically irrespective of any reason, okay. So there is no need to be a specific reason, okay. So parole should be granted to certain category of you can say convicts on the basis of, or you can say timely it is given. And second thing is there should not be any specific reason, okay. So that is there. Other than that, it is a matter of right and merely to enable the prisoner to retain family and the social ties. Because let's say if there is a person who is inside jail for like 14 years, so there are high chances that he will be disconnected or detached from the society, from the people or the relatives, and to avoid that this is done, okay. Now moving further, here you will be seeing it is a conditional release with no uniform legislations. It is given in case of long term imprisonments, okay. The period of furlough granted to a prisoner is treated as a remission of his sentence, okay. As I told you, let's say when we are talking about the parole, if there is a person who is out for a month, okay, then he has to be inside the jail of 1 month extra. But when we talk about furlough, if there is a person who is outside 15 days, then he need not to be inside the jail for the extra time being, okay, because that is considered as a remission, okay. Now here legal backing, if we talk about the parole and furlough, that is been derived from the Prisoners Act 1894. Now section 59 of the Prisoners Act empowers state to make rules for the shortening of sentence as a reward for good conduct, okay. Now these are powers given to the states, okay. Both parole and furlough are considered as the reformative processes. These provisions are introduced with a view to humanizing the, you can say, prison systems, okay. So that is about the legal backing. There is this act, that is Prisons Act 1894. Now what is the difference? We have seen that first is awarded in the case of short term detention. When we talk about parole, it is given in the short term detentions, and when we talk about furlough, it is given in the long term detentions, okay. And the period of release does not count towards the total period of sentence. As I told you, they have to serve extra, and in this case here it will be counting towards the total you can say period of the sentence. So we can say that it is kind of a remission which has been provided by the state, okay. Then duration, it lasts for 1 month, and when we talk about this maximum 14 days, it can be extended, but minimum that is 1 month and then 14 days, okay. Then coming to the next one, that reasons in the case of parole, okay. So there should have been a reason, okay. Second thing is it is not a matter of right. It is not a matter of right. Furlough is a matter of right, okay. So since it is a matter, it is not a matter of right, that means there is a discretion of the issuing authority, and issuing authority will be deciding on certain factor, and there should be a reason for that, okay. A specific reason should be there. In this case, there is no need to have a specific reason, okay. Who will be the granting authority over here? Here divisional commissioner, and here will be the Deputy Inspector General of you can say prisons, okay. So these are the two authorities which will be giving the furlough and parole. Then declining request, it is granted at the request of the prisoner and can be denied. As I told you, it is not a matter of right, and it is a matter of right, it is not denied, okay. Then frequency, it can be granted multiple times and it can be given limited times, okay. So that is the difference between, you can say, parole and furlough, okay. So that is about it. Now moving to the next one, that is legal parental right in ART. I have told you that what is ART, that is assisted reproductive technologies, okay. We have talked about it. Now coming to the direct issue, as I told you that there was this case in front of the Supreme Court wherein they have to decide on the legal rights of a donor as well as the kid as well as the, you can say, biological or the commissioning couple. Okay, now the thing is, there was this case wherein a person has actually a couple has gone for, you can say, taking eggs from a donor, and that donor was sister-in-law. Okay, now after some time the husband of the sister-in-law dies, and then there was some kind of romantic relation which actually generate between the husband of the commissioning couple and then you can say the sister-in-law who has provided the eggs. Okay, and after the child is born, then they have taken the custody of child as well. Now the mother who was the part of the commissioning couple, she has gone to the court that basically that child is hers and she would also be given some kind of visiting rights. Okay, in that case, court has decided on the rights of various sections. Okay, so let's see. Assisted reproductive technologies, let's talk about that. ART includes techniques for obtaining pregnancy by handling sperms or eggs outside the human body and transferring the gamete or the embryo into the reproductive system of a woman. Okay, so what will they be doing is that they will take the sperms, okay, and they will be taking the eggs. They will you can say go for you can say gamete generation in the laboratory. Okay, so once this gamete or the embryo is generated, that will be transferred into the womb of a, you can say, mother. Okay, ultimately after that they will be going for the normal process. These include gamete donations like sperms and egg, in vitro fertilization, and the gestation surrogacy. Okay, so that is there. What is the eligibility criteria here? So a bank may obtain semen from male between age of 21 and 55 years, and when we are talking about female, that is the age 23 to 35 years. Okay, so these are the people of age who can go for the donation of their specimen. Then moving further, the woman may donate eggs only once in her lifetime. Okay, donate eggs only once in her lifetime, and not more than 7 eggs may be retrieved from her. Okay, so once she has donated from that particular specimen, they can only retrieve 7 eggs. Okay, so that is about the eligibility criteria for the donors. Now what is the conditions for the offering of the services? ART producers must be conducted only with the written consent. There should be a written consent of both the parties. One is the commissioning party, okay, like the couple, and then second is the donor. Okay, that is one thing. Commissioning party would be required to provide for the insurance coverage of the donor. Okay, so that is their rights of child born through ART. Now the child born through the ART will have all the rights of a child who is born from a natural process. Okay, so he will be having the similar, he or she will be having the similar rights as of a child born out of a natural process. Okay, so that is there. A child born through ART will be deemed to be a biological child of the commissioning couple. Okay, and that he will be a child of the commissioning couple, and the donor will not have a much say in that. Okay, so will be entitled to the rights and privileges available to a natural child of the commissioning couple. Okay, then the donor will not have any parental rights over the child. As I told you, donor will not have much say, so he will not have any kind of parental rights. Okay, he or she will not have any kind of parental rights. In the recent case also, the Supreme Court has said that the donor, or that is the sister-in-law, will not have any kind of rights in the, you can say, or any kind of parental rights. Okay, so parental rights will be with the commissioning parties. Okay, now here legal aspect, if we see here, you can say the parental rights denied by the law. So in this ruling, the Supreme Court ruling emphasized that the sperm or the egg donors have no legal parental rights under Indian law, particularly Surrogacy Regulation Act 2021 and ICMR guidelines. Okay, so that is the act which is basically guiding the procedure. Other than that, we have ART Act as well. Okay, so that is their judicial role in the clarification. So in this particular case, they have delved deep into the you can say all the legal aspects, and they have decided that the whoever is the donor here, they will not have the legal parental rights. They will just be they will be, you can say, biological parent. Okay, but the thing is, they will not have any kind of legal parental rights. Okay, so here you can say this ruling sets a precedent for the future cases, establishing that the genetic link do not equate to the legal parenthood in the surrogacy disputes. Okay, so that is the current position right now. So I hope that is clear. We have discussed all the aspects which we wanted to. Now coming to the next section, that is test. We will be discussing 3, 4, 5 questions, and you have to answer these questions in the comment box. Okay, so first question is, which article of the Indian Constitution empowers the president to specify caste, races and tribes as scheduled castes? So here you can see Article 14, Article 15, Article 341 and Article 342. Okay, now moving to the next question. Before that, you can answer about this question in the comment box. Moving further, who is responsible for overseeing the regulation of securities market in India? Here RBI, Ministry of Finance, SEBI and the National Stock Exchange. Okay, so you have to understand the question and then answer, and you can reply me in the comment box. With reference to India, consider the following statement: when a prisoner makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of his or her right. Okay, so they are talking about parole here. Now you have to see that whether they have such right or not. Second thing is, the state governments have their own prisoner release on parole rules. Okay, which of the following statements are correct? You have to choose the correct statement and then you can reply. Moving further, that is basically in the legal context, what is the role of egg donors according to the court? Legal mother. Then second is the genetic mother with no legal rights, co-parent with the legal rights and guardian of the child. Okay, so you can attempt the question and answer me in the comment box. So with that, we would like to wrap up this particular session. I'll see you in the next episode. Till then, have a good day. Thank you. And if you have not subscribed the channel, please subscribe it. Have a nice day.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.